Hi, I'm Brian with Hanning Law Limited, an attorney to businesses and creators. Today I want to talk about technology and copyright. And as a little background, I try to stay on top of what's going on. So I browse LinkedIn to see what all of the entrepreneurs are doing. I have Twitter to follow some cool artists. I follow major news networks. I follow legal blogs. And when a topic keeps coming up, I naturally get interested. And so that technology that's kind of bubbled to the surface right now is an NFT, a non-fungible token. I've linked a major article down below so that you can get a better idea of what it is, because I'm a lawyer and I'm going to talk about the law. So when we're looking at copyrights in regard to technology, a copyright is an original work of authorship fixed in any tangible medium now known or to be developed, where the work can be perceived, replicated, or communicated. In other words, if I can create some technology to share my writing, to share my drawing, which is terrible, and you're able to see it, there's a copyright there. There is legal protection. Now, we're not going to touch registration here. Registration gives you more rights. But when you've created something, you get a whole bunch of rights. It's the right to distribute it, the right to perform it, the right to create variations and sequels and derivatives. Derivative sense of I wrote an amazing story as a book and somebody's bought the right to make it as a movie. Or I've written a book and somebody's bought the right to translate it into Spanish or something. And the thing with new technology is not that copyright doesn't vest. The thing is we are looking at how does copyright law apply to this new technology. And I think there's a couple of things to keep in mind regardless. The first thing is that copyright is author driven. So if an author creates something, they get the right in any way it's communicated. So if I write this story, I have the right to perform it online, to film it, to send it out as a book, any of this. It's all my right. It's my work, my control. It doesn't matter if the technology is new. It's still my right. Second, I have the ability to transfer or sell that right. And in doing so, I can permit other people to use it. So if I wanted to, I could take my book, put it on an NFT, and sell that on. That is entirely within my prerogative. Third, intellectual property crime exists. And the Copyright Act and other intellectual property acts have criminal elements to it because there are people doing crimes. It's my property. If I'm not authorizing or allowing somebody on my behalf to authorize, then somebody putting it out there without that authority is potentially committing a crime. And finally, you don't have to go alone. Yes, this is an author-driven thing, but there are organizations such as Attorneys for the Arts organizations, such as legal service organizations, that can help you understand what those rights are, how to define and understand them. And there's also the Justice Department and other investigative organizations that pursue people who are doing things intentionally and without permission. So I'm going to provide links below, links to Colorado's Attorney for the Arts organization and a PDF authored by the Justice Department on how to report intellectual property crime. And I just want to remind you that technology and copyrights go hand in hand. As technology changes, how and what we create and distribute and share with each other changes. It's not always a good thing, it's not always a bad thing. It more or less just is. So, new technologies, apply it to old law. We got lots of questions, but we do know some things. See you all next week.